Hey guys, it's Kathy. Hope you're doing well. Okay, we're back to OJ. We left crazy Mr. Kelly, and now we're back to OJ. Yeah, it's not a good day for celebrity. Yesterday was not a good day for celebrity types. Man. I don't even want to press play because I'm just so sick of this guy. Here we go. Oops, he's muted. Should I just leave him muted?
Checklist.
Original copies?
Yes. The originals.
Original copies
Thank you.
again.
The documents that have been brought to us that purport to be originals of the crime scene investigation checklist.
The four pages? The 4-page sheet.
It's actually 1, 2, 3, 4 pages that are numbered, a 5th page designated field notes, and on the back of the 5th page there is writing. A 6th page designated field notes that's blank, and in the back page of that is a diagram. A 7th page that is the evidence collection checklist, and on the back of that there is another diagram. And what did I say? This is the 7th page, which is a second evidence collection checklist. Is that 8 altogether?
Pages. 8 pages.
8 pages.
All right, those pages will be 1107.
I'm sorry, I thought we were going to introduce any of the originals that we can maintain, custody of our originals pursuant to required.
If there's a reason to use the originals, I'll allow their use. However, there'll be substitutions for the record.
No, you have to be extra nice to him.
Now, earlier, Mr. Fung, you were shown a copy of this page by the prosecution, and it was introduced into evidence on your direct examination.
Yes.
All right. And this piece of paper contains handwriting of Andrea Mazzola,
Yes.
where she lists various items.
Yes.
And when you say this page, which page are we talking about?
It's the page in back of the field notes.
First page of field notes?
All right.
All right.
I'll give you a number in terms of the actual page. It is the 5th page, and it's the back of the 5th page, and I'd like to put this on the Now, in this document, you can read along if it helps with your copy if you want, refers to item 17, 1 pair tennis shoes Reebok received in serology by D. Fung from Detective Lang, correct?
Yes.
And up in the upper right-hand corner, just where D. Fung is, there's a date, 6/14/94.
That's correct.
And below that is written item 18, blood sample in tube from Simpson.
That's correct.
And item 19 is hair from item number 9.
Yes.
And that is, item number 9 is the Rockingham glove.
Yes.
And the hair that's being referred to is a hair that you removed on the morning of June 14th.
Yes.
And the sneakers are sneakers that you received in the morning on June 14th.
Yes.
And it's your testimony that the blood sample from Mr. Simpson you did not receive after the sneakers on the morning of June 14th.
I received the sneakers on June 13th at 5:20.
And on direct examination, you mentioned that you saw this document when you came back to the laboratory on June 14th.
At some point, when I was writing my property report, I saw this document.
I'm sorry, did you misspeak and say that you got the 13th, the sneakers on the 13th?
I believe I
You got the sneakers on the 14th.
got the sneakers on the 14th. I got the blood on the 13th.
Now, you might have seen this document then, not on June 14th, but June 15th. You said you saw it around the time you were writing up your property report.
Possibly.
So you're not sure whether it's the 14th or the 15th that you saw this document.
It was when I was writing my property reports. I could check. It was on the 14th.
So on the 14th, you saw this document.
Yes.
And when you looked at it, you decided that you didn't like the order in which Ms. Mazzola had put down the receipt of these items.
When I was writing my property report, I wanted to save on paperwork, so I changed the order of the item numbers that she had written down.
And then on, this is page 8 of the Rockingham report. In your evidence collection sheet, you told us that you went back and you changed what had been, what Ms. Mazzola had written as 17 under sample item, correct? Top of that page is a reference to the item received by you from
You're going to
Detective Lang.
have so much fun.
Yes, the very top line.
Yes.
Yes.
And Ms. Mazzola had written 17 there.
At one point in time, yes, there was a 17 there.
I want
And
to
you
come
changed
with
that
you.
to an 8.
Yes.
And then below that indicated 17 for the blood sample.
Yes.
And on direct examination, you said you did that on June 15th.
Mistakes in testimony.
When did you do it?
It was either the 14th or the 15th. I don't recall.
And on the morning of June 14th, you gave Colin Yamauchi Mr. Simpson's blood vial,
On the morning of
the 14th.
14th,
The record should reflect the witnesses.
Vegas, baby.
Yes. with
May I
his
approach
notes.
the witness?
You may.
to the best of my recollection, that's when it was on the 14th that I released custody to him.
And he poured off some blood and gave it back to you.
No foundation for personal knowledge. So
Okay.
Did Mr. Yamauchi then return the blood vial to you on the morning of the 14th?
After I gave it to him, he did return it to me. Yes.
Did you actually see him taking blood out of the blood vial on the morning of the 14th?
I don't recall seeing him doing that.
Now, on direct examination, you were asked whether or not you recalled what item number you told Colin Yamauchi the blood vial was.
I don't recall that testimony.
Well, do you recall that you were asked that question and you said you didn't remember which item number you told Colin Yamauchi the blood vial was on the morning of June 14th?
I don't recall what my testimony was at that point.
Do you recall whether or not you told Colin Yamauchi what item number you had designated the blood vial on June 14th?
I told, or from records that I have come in contact with, I told him it was 18.
When did you first learn that Mr. Yamauchi had recorded the blood vial as being item 18, not 17?
When did I first learn this?
Yes.
After I had written my property reports I went to tell him that I had changed the item numbers, and that's when I found out that he had written the report and put down the item number as 18.
And was this a cause for concern that Mr. Yamauchi had written down number 18 for the blood vial and not number 17?
Sustained.
Was this a cause of concern for you that Mr. Yamauchi had actually written down number 18 as the blood vial, not 17?
As a matter of keeping things clean, as far as having to write follow-up reports, yes, it was a concern to me.
No. You said it was a matter of keeping things clean.
Paperwork-wise, yes.
Well, weren't you very concerned that if the record showed the blood vial being received after the sneakers, that might reveal that the blood vial was actually received on the morning of June 14th, not on the afternoon of June 13th?
That was not a concern, no.
Never entered your mind.
I was more concerned about having to write up a follow-up report.
So that thought never entered your mind.
No.
Never a concern that anybody might look at this mislabeling and think that the blood vial had not been transferred to you on the afternoon of the 13th, that actually had been turned over on the morning of the 14th.
Sustained.
No concern on your part that the fact that Mr. Yamauchi had labeled it 18, not 17, might lead someone to question whether or not you had actually received the blood vial on the afternoon of the 13th as opposed to the morning of the 14th.
That did not occur to me.
At some time after June 15th, did anybody ever question you about how the blood vial had been labeled 18 in Mr. Yamauchi's reports, but you put it in your property report as 17?
In testimony, yes.
It arose for the first time in testimony?
Being questioned about it, yes.
No one in the laboratory ever came to you and asked you how something like this could happen, that Mr. Yamauchi had recorded the blood vial as 18, but in your property report, you said it was 17?
I told Mr. Matheson about it. I told Colin that I had done it. The
Colin.
changing of
Colin is who?
Mr. Yamauchi, I'm sorry. I told Mr. Yamauchi that I had changed the item number. I'd flipped them around. And that was the conversations that I had.
And that conversation happened around when?
Shortly after I had written the property reports and was going to tell him that I had changed the item numbers.
And that was in June.
Yes.
Did anybody come to you in July and question you about the fact that the blood vial had been labeled 18 in Mr. Yamauchi's records, but 17 in your property report?
No.
No conversation about that at all in July?
None that I can recall.
No concern in your part in July about the fact that there had been this confusion, as you put it, between 17 and 18?
It wasn't.
It's not confusing.
Well,
Nothing
wasn't
about that
confusing
was
to me.
confusing.
No concern. No, did anything in the month of July cause you to go back over your crime scene checklist records and make changes?
I may have gone in and added some information that I had remembered and added things that I recalled into the crime scene checklist.
Oh, but nothing concerning this question of 17 and 18?
No.
Now, you know Mr. Yamauchi. You know Mr. Yamauchi, right?
Yes, I do.
Yes. Now, you know, Mr. Fung, that questions have been raised about whether or not all the blood in Mr. Simpson's blood sample can be accounted for.
Sustain the first question.
It's
All right.
ramen. Don't get
Are
excited.
you aware that the defense has raised questions about whether or not all the blood in Mr. Simpson's blood sample can be accounted for?
Overruled.
I'm aware of that.
And before the defense raised these questions at this trial, did anyone in the laboratory ever ask you any questions about whether or not there had been any tampering with Mr. Simpson's blood vial?
I don't recall anybody asking me if it was tampered with, no.
Well, were there any questions asked of you about that subject by Ms. Kessler?
I don't recall her asking me
Mr.
that.
Matheson,
I don't recall him asking me that.
was there any ever, were you ever asked any questions by an investigator from the district attorney's office about possible tampering with Mr. Simpson's blood vial?
No.
Now, didn't you go back and look at these records in July to see whether or not you had adequately covered your tracks about the fact that
Let's,
you really,
let's rephrase that question.
All right.
counsel.
did you look back through these records, these crime scene checklist records in July, with the concern that there might be something there that would reveal that you really didn't receive Mr. Simpson's blood vial in the afternoon of June 13th, but you really received it on the morning of the 14th?
That was not a concern to me because that's not what happened.
Okay? I direct your attention to, there's an erasure, is there not, between items 17 and 18 on this document.
Yes, there is.
And what had been there before was a circle and a 7-5-94, and underneath it, your initials, DF.
That appears to be what appears to be on the screen, yes.
And then
Yeah,
there's,
counsel, if you're showing him potential erasers on the Elmo, you should show him the original document.
please take your time and examine it.
Who else? Who else just heard Judge Crawford say, Mr. Kelly, if you're going to do that, we have rules.
Now, in that erased portion, you had written 7-5-94 within a circle, and within that circle, you put your initials DF.
Yes.
And you put a line with an arrow on the top of it and an arrow on the bottom of it
Yes.
to indicate that those items should be switched, 17 and 18, as written on that piece of paper.
I don't know why I wrote it, but yes, it's there.
So you took a look at that piece of paper and you became concerned about the fact that the sneakers were 17 and the blood vial was 18, right?
Yes.
And that was in July, when you were going through these pages, that you had that concern.
Apparently, yes.
And then after writing that notation, you decided to erase it.
I did erase it from what's here. Yes.
And in going through the pages of the crime scene checklist, you saw another document that created a problem for you, didn't you?
What are you referring to?
I'm referring to page 4 of the crime scene checklist.
What
I
about it?
highly
Page
approve.
4 of the crime scene
I
checklist.
did. I forgot. So CJ sent me chicken salt from Australia, and I tried it on thighs. I tried it on thighs like, I don't know, gosh, it was like a week or so ago. It was really, really, really good. You guys should definitely get some. and try it out. Chicken salt.
Has a box
Thank you, CJ.
indicating disposition of evidence. I should say disposition of scene.
Yes.
Okay. Page 4 has a box indicating evidence book 2,
Yes.
evidence book by,
Yes.
disposition of scene,
Yes.
and most importantly, sir, it has a box indicating time leaving scene.
I don't know if that's the most important box, but there is a blank there.
There's a box there that indicates time leaving scene, doesn't it?
Yes, there is a box there.
And Ms. Mazzola had been the one that was filling out these reports.
She was filling out the crime scene checklist that day.
And Ms. Mazzola was under the impression that you had left the Rockingham scene earlier than 5:20, wasn't she?
Calls for speculation.
Sustained.
Do you know if Ms. Mazzola was under the impression in June that the two of you had left Rockingham before 5:20?
Calls for hearsay.
Overruled.
I don't know when she thought we left Rockingham.
5:20 is the time that you wrote on the gray envelope you received it from Detective Van Adder.
Yes, it is.
If there were something filled in there that said 5:15 as to the time leaving scene, that would be inconsistent with what you wrote on the gray envelope you received from Detective Van Adder.
Overruled.
If there was that time there, yes, it would.
And that's why you destroyed the original page 4, Mr. Fung.
That's not true.
Mr. Fung, I'm going to show you each of the originals of this crime scene checklist. I want you to look at them. I want you to look at the upper left-hand corner of each of the pages. And that would include, let me put it in order for you.
You may.
Why don't you and Mrs. Goldberg look at the left-hand corners, all those pages of the crime scene checklist very, very carefully. One of those pages doesn't have staple holes in it, Mr. Fung.
That's correct.
That's page 4, isn't it?
Yes, it is.
That's because that page 4 is not the original page 4.
That's apparent to me now, yes.
That's because you got rid of the original page 4. Isn't that true, Mr. Fung?
That's not true.
That's because it had the wrong time on it. Isn't that true?
If it had the wrong time, no, that's not true.
Your Honor, I'd like to do 2 more.
I love Fung.
questions.
I love him.
What I would like to do is first have printed out on Momo a copy of the document with the erasure. And then I would ask that each of these documents be handed to the jury so they can examine them.
All right, let's print out this document on the Elmo.
This is printed out at 1107A, and well, the printout will be 1107.
Get on that.
It's really, really good.
please.
Okay, I was
All right, back
on.
on the record.
Shh, Ito, shh, be quiet. No one talks when I talk, Ito. I was just on Amazon looking for chicken salt, and I didn't find the one that CJ sent me. No. But then I saw bacon salt when I was looking at it. And then right underneath bacon salt, big word, vegan. Vegan bacon salt? Wait, what? Vegan bacon salt. How?
Record to reflect that we've been rejoined by all the members of our jury panel. Mr. Scheck, have you concluded your cross-examination of Mr. Fung?
Yes, I have, Your Honor.
All right, redirect examination, Mr. Goldberg.
Good evening, Mr. Fung,
Good evening.
ladies and gentlemen. Mr. Fung, let me see if I have this.
I'm
Were
going to add
you
it to my wish
involved
list
together
anyway.
with Detective Lang, Detective Furman, Detective Van Adder, Michelle Kessler, and her husband, whoever that might be, in a conspiracy against this defendant?
What's the objection? Grounds? Full.
No,
Were you involved in some kind of a conspiracy with Andrea Mazzola to cover up receiving some item with your bare hands?
no,
Were you involved in any conspiracy with Detective Van Adder to allow him to keep a vial overnight so that he could do with it what he pleased?
no,
Or with Detective Lang to allow him into the evidence processing room so that he could somehow maybe take the defendant's shoes and in some way get any DNA that might be on them, on the swatches and the controls?
Grounds?
Compound, speculative.
Sustained on the leading ground.
Were you involved in any conspiracy whatsoever with Mr. Lang to allow him into an evidence processing room?
no,
Overruled.
Or with anyone in this case, Mr. Fung?
nobody.
Now, Mr. Fung, do you recall that on a cross-examination, an issue came up as to one of the pages from the crime scene identification checklist, the original of which was missing?
Yes,
And do you happen to have a Xerox copy of that page now?
no,
Not the original, but a Xerox.
see that leave it.
And we're referring to 1107, correct?
I don't have one, no.
And did you find the original of that document?
Yes, I did.
How did you do that?
I opened up my notebook and examined that page, and it was there.
Now, there are two notebooks that are sort of similar that you've seen. One is the notebook that I'm holding in my hand. Is that correct?
Yes,
And then you have a notebook in front of you.
yes,
And for the record, Your Honor, these are blue notebooks about an inch thick or so.
Appear to be.
And is your notebook your own personal notes that you maintained?
yes.
So you found the original of that document that was missing in your notebook.
Which document, which item number
Yes.
for the record?
It's a little obscure.
It was part of what's been marked the crime scene identification checklist. I believe that's defense 1107 for identification.
Yes.
That was page 4 of the,
No, not page 4, the other page that talked about giving certain items to Mr. Yamauchi.
yes.
That's leading. And I'd like to know which document, I think the record should be clear as to which document you're talking about.
Sustained.
Okay,
Raise the
I
question.
can,
please.
I'll introduce it, Your Honor. Your Honor, this is a page entitled Field Notes, and it has in the upper left-hand corner the date of 6/14/94, and then lists certain items. Counsel's familiar with it.
All right. People's next in order.
Yes.
People's 181.
May I approach?
You may.
So show me People's 181. You recognize that?
Yes, I do.
And what is it?
This is a page
There's no way
that
to
I
add it
use
to my
to
list.
record
Look.
the
Why can't I add
transaction
it to my
of
list?
items when I release them to Mr. or
Am I
criminal Yamauchi.
stupid?
And is that the original?
Yes, it is.
There's no way
Now,
to
generally
add
speaking, the
bacon salt
documents that you have in your
vegan
notebook, are those originals or
to my
copies?
list. Wait,
The
we
ones
need
I
to
have
go-
in my notebook are generally copies.
Yeah.
Showing you the notebook that I have in front of me. I think you've seen this before, but are these supposed to be the
I
originals?
am
or
stupid.
These should be the
I found
originals.
it.
So in some manner, the original of that document got into your notebook instead of
I
the
added it
notebook
to
that's supposed
my
to contain the
list.
originals.
Yes,
During the recess, sir, did you have an opportunity to look in your notebook and find the original of page 4?
yes,
Your Honor, at this time, I'd like to mark as people's next in order That's Exhibit 182.
182.
A document that has page 4 at the top, and it has various writing, all typewritten, but it's not filled out.
We're supposed to be watching the OJ trial.
Now, sir, you testified that you were a firearms examiner. Is that correct? Right now?
Yes,
And do you also do tool marks?
I have, yes.
I'd like to show you what's just been marked as People's Next Exhibit, page number 4. Will you take a look at that?
Was
sir?
that the same brand?
Yes,
I
And
thought
will you
yours
take
had
a
an
look at the
orange
staple
label.
holes in the upper left-hand corner?
yes,
I'm now going to show you the document that was marked as Defense 1107
It's
for
good.
identification.
You're gonna love it.
Do you recognize this?
yes, I do.
Sir, can you please visually compare the staple holes on page 4 to the staple holes on the succeeding page? Have you done so?
Yes,
And can you form any conclusions about that comparison,
I can form a preliminary conclusion.
which is?
They appear to have, this appears to be the document that was missing from this set of originals.
When you say preliminary, you won't form a final conclusion at this time, is that right?
Not at this time,
And
no.
why is that, sir?
I feel I would have to go back to the lab and look at it under a controlled situation with a microscope and other tools.
And that would be the standard practice for a forensic scientist.
Yes,
Your Honor, at this time, could we pass those documents, Defense 1107?
You must approach. Your Honor, may we approach?
This is so freaking stupid. And we're watching it. And we know it's stupid, yet we continue to watch. What is Marsha doing there? She's going to get in trouble? Judge is going to yell at her? Oh, look, 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 look. He's mad.
All right, ladies and gentlemen, I have to let the court reporters go so they can catch their train, and I told them I'd let them go 10 minutes to 6. Because of our computerized court reporting system, after they finish the day, they then have to take the floppy disk and then download it to the main computer and all of that so we can produce our transcripts every day. And they then have to catch the train. So we're going to take our break right now. Mr. Fung, you can step down. You're ordered to be here tomorrow morning at 8:30. All right, ladies and gentlemen, we're going to stand in recess until tomorrow morning as far as the jury is concerned until 9 o'clock. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Do not allow anybody to communicate with you with regards to the case. Have a pleasant evening. We'll see you tomorrow morning at 9 o'clock. All right, we'll stand in recess. And counsel can remain to view exhibits before we break. All right, thank you.
I think the record.
All right, Mr. Fung, why don't you wait outside for us? Thank you. Mr. Schick.
Thank you, Your Honor. And even if one gives every reasonable assumption to the prosecution in terms of this course of conduct, I don't think that there's any question. But what happened here was a deliberate and intentional misconduct on the part of the prosecution. In making this argument and in drafting a proposed instruction to the jury, I intend to follow very carefully this court's decision with respect to the videotapes in the Rosa Lopez matter. In this court's decision, with respect to failure to disclose certain matters of discovery, the first factor that the court began to look at was the history of discovery proceedings up to this point. First, other factors, other problems that have arisen. And I would note for the court that there have been quite a few problems with respect to the discovery on evidence collection. First, there's the matter that the court still has under submission of the failure to disclose the videotape of Mr. Simpson's residence, which has some very material information in it, in particular, the time in which the tape was taken and the very suspicious absence of the socks as the camera pans Mr. Simpson's bedroom and what the prosecution is saying about 414. More disturbing still is that the prosecution indicated that they had turned over to us the serology room transaction cards, which would indicate who went in and out of evidence processing room transaction card sheet, indicating who would go in and out of the evidence processing room on the morning of June 14th.
That's false, Your Honor.
Wait. Mr. Goldberg, you know how this works. All right, proceed.
Mr. Goldberg turned over these printouts of the evidence processing room. And to give him every benefit of the doubt, what he has told us is that he turned over what he had, which did not include the times of the early morning. It only started, I think, around 9:40, but it didn't include the early morning. And he indicates that in terms of what he had, he didn't have it either. All right. And he didn't give us a complete set. That's what he says. Let's just take it as he says it. Nonetheless, we didn't get it. We eventually got it during cross-examination, in the middle of the cross-examination of Mr. Fung, but that happened. Then there are other disturbing problems with respect to our access to this evidence, and that is that with respect, for example, to the hairs and fibers from the hat found at Rockingham, a bindle was created by Dr. Lee of hairs and fibers that was removed in Albany.
Isn't that a factual issue that I haven't resolved yet?
Oh, no, I understand that. I'm just saying the state of the record. I'm trying to be as objective as possible in setting the background for what I think is the real egregious problem here.
No, but you're citing something to me that there's no factual determination that did or did not happen. We are aware of the LAPD video that was turned over in a light manner. I'm aware of the barcode, I mean, not the access card records.
Right.
All right. But this other stuff I'm not familiar with.
Well, no.
I've heard it. It's not in the record.
Well, I don't. Well, I think it is in the record in terms of, and I don't think there'll be any dispute that what's happened here is that and Mr. Yokelson is still searching for it. I mean, and we've been talking about it, and they're searching for it. But the fact of the matter is that these hairs and fibers were taken off the hat. A bindle was created. It was photographed back at the crime lab, and they haven't found it yet. There is again the matter of the lens and the prescription glasses, which again is at this point unaccounted for. The reason I raise this, Your Honor, is that the difficulty that I have here, and I think it fits into one of the factors that the court considered on the discovery sanction, and if I may quote you, is that what you're looking for in terms of these discovery sanctions is that we have to assume that on important issues that an absolute bare minimum of professional competence would require that the lawyer preparing to present testimony of witnesses confirm an inventory of statements, reports, notes, recordings, etc. Now, all that I'm saying here, Your Honor, is that I think that there's a clear pattern that in this discovery that what's been going on is that the prosecution is far more concerned with what they think the defense is going to find than they are in ensuring that they are really turning over to us all the evidence in an accurate and complete form. And that the fact of the matter is that I'll proffer to the court what's been going on, as the court's well aware, is that we go to the laboratory and we have visits and we try to examine documents and evidence, and everybody sits there and they take notes about exactly what we're looking at and exactly what we're thinking.
Well, Mr. Scheck, what I'm really interested in, though, are the facts and circumstances that surround page 4.
I understand. I think that's a necessary backdrop because it's a factor that the court's considered. As with respect to page 4, I think that this is a clear statement of the record. We went and visited the LAPD laboratory and asked to examine the original notes of the crime scene checklists at Rockingham and Bundy and everything that was filled out by Ms. Mazzola and Ms. Fung. That was delivered to us at the SID laboratory in the presence of Mr. Goldberg by Greg Matheson, and they gave us a book that purported to be originals. There are 2 laboratory notes that were taken by, I believe, Mr. Matheson at this time that actually document this and document how Mr. Neufeld was looking at the original notes of Fung and Mazzola And we went and asked if we could copy them, and how I was looking at the field notes while Mr. Neufeld was checking his notes. There are records of them watching us, looking at these documents with great care. I'm sure Mr. Goldberg will not dispute that at that evidence lab, when I looked at those original documents, obviously I was very concerned, because I thought that, I asked Dr. Lee to come over and look at it. I thought that I found a discrepancy in terms of the originals. I asked Mr. Goldberg if we
All
could
right,
copy
excuse
it.
me a second. Mrs. Robertson, can I have both page fours, please?
I asked Mr.
All right, I'd like to see this. All right. Go ahead.
I asked Mr. Goldberg if we could make a copy of the originals. He was reluctant to do so. He didn't want to make a copy of the originals right there in the lab. I then appealed to Mr. Yokelson, and Mr. Yokelson agreed, and a copy of those originals was then turned over to the defense. Subsequently, as the court is well aware, we made a specific request, a written request, to have all the original documents from the checklists examined by a document examiner. The district attorney's office balked and asked that I make an offer of proof, or they contested our right to have a document examiner look at the original documents. What they were telling us were the original documents. As the court, I'm sure, recalls, I made an ex parte offer to the court. And in that ex parte offer, I explained to the court very clearly what I thought the problems were, that I had seen this erasure with respect to somebody going back over the documents on July 4th, that we didn't see any staple
July
holes.
5th.
I'm sorry?
July 5th.
July 5th. That we did not see any staple holes on page 4 of the Rockingham checklist, and believed that that was not an original. And I wanted to have an expert examine that in the other documents. I explained to the court at that time that it was our contention in this case that we did not believe that Mr. Fung had ever received Mr. Simpson's blood vial on the afternoon of June 13th, but in fact had received it in the morning. I further pointed out to the court the written documentation on where Ms. Mazzola had indicated that the blood vial had been received after the sneakers. I further pointed out to the court her testimony at the split hearing, which Your Honor heard, in which she indicated that she did not recall, essentially, seeing Mr. Fung receive this blood sample from Detective Van Adder on June 13th. So the document examination occurred, and we were operating on the assumption, because it was a representation by the prosecutors, that the documents we were looking at were originals. I don't think there's any question. The prosecution concedes now that that was a false representation. We were not looking at originals, that in fact, page 4, they are claiming, was not the original. And it was perfectly plain, I think, after document examination, that that page 4 was not the original. And we relied upon that representation. During the course of Mr. Fung's testimony, he made representations, and it was our understanding from looking at the manual, that all original documents are supposed to be kept in one place within the laboratory, and that they're collected there for purposes of review by supervisors. And he agreed that that was true, and that the documents that had been segregated were the originals. Then there was another document. I'd like to get the exact, it was first introduced by the prosecution. And that was a document that had an L number on it, and it referred to, it was undated. It was written on a field report note. L16, and there's a specific prosecution number at one, I can't recall what the number was, but it was used with Mr. Fung on direct examination. Mr. Yokelson, Mr. Hodgman, and Mr. Goldberg represented to us that they had not yet found the original of that lab sheet. So on direct examination, an original was not used, an original had not yet been located. The day before, I guess it was the day before yesterday, maybe Mr. Goldberg knows it better than I do, but I think it was the day before yesterday, which would make it Wednesday. Mr. Goldberg turned over the original. They had found the original. Presumably, I take it from what they're saying, that they found the original in Mr. Fung's own notebook. That, I would submit, Your Honor, should have put them on notice that perhaps they had not turned over all the originals to us, as they had represented they had done, and it was a representation, obviously, that we were relying upon, and relying upon heavily in terms of framing a final line of cross-examination. So I would say at this point, in terms of the court's discovery analysis, that certainly we have a false representation, and the question is whether it was inadvertent neglect or gross neglect. I would submit at this point we can at least assume it's gross neglect, and let us assume that it was not knowledgeable or intentional up to this point. In other words, when I was cross-examining Mr. Fung yesterday, even after they realized that there might be some originals in his notebook and some of the documents they gave us were not originals, let us assume that they did not know and they were not intentionally trying to set us up in terms of the cross-examination. All right, it's just a gross neglect at this point. However, what happened afterwards clearly is intentional misconduct. This was an important witness, and the issue here was a critical one. Whether or not this blood vial was turned over, we all know that we're about to broach the issue in opening that about a quarter of Mr. Simpson's blood sample is unaccounted for based on the records that we had been given up through the opening statement, and we opened on it, and we think that that is an extraordinarily serious issue in terms of tampering with evidence. It goes to the heart of this case. Mr. Fung had been impeached on many points that I think it's fair to say have damaged his credibility in terms of other important pieces of evidence. The Bundy glove, the movement of those, which he can't account for, an envelope where he was, taking it with his bare hand, where that was caught on videotape. But then, of course, the most important fact of all is that during the examination yesterday, and I must say that the court extended every possible courtesy to the prosecution in terms of allowing them to look at these videotapes. You handled it very, very carefully, trying to prevent trying to prevent any unfair surprise. I mean, they were given all the videotapes. The only thing that I was reluctant to reveal to them openly or in an offer of proof to you is that by looking at the cars, we had ascertained that Mr. Fung's testimony that he had carried a blood vial out in the brown bags, the posse box, or in his own hands was false. But in terms of giving them the real evidence, they had it. They had an hour to look at it. They had a long time to think about it. The court conducted the examination outside the presence of the jury. It was done by the book. What happened here, however, Your Honor, is that at some point in time, before I finished my cross-examination, before I stood up after the break and said no further questions, the prosecution, if we take them at their word, went through Mr. Fung's book and discovered the original page 4. Given their representations that they had given us all the originals, the proper course of conduct at that point would have been to inform the court and counsel that their prior representations had been false. They purposely did not do that. Instead, what they tried to do was begin a direct examination to rehabilitate Mr. Fung in an unfair way, to try to rehabilitate his credibility on this critical issue of whether or not he got the blood vial on June 13th as opposed to the morning of June 14th. And they then began to do that on redirect examination.
Issue.
I heard the first question about the one sheet that they had originally told us was not an original and they'd found the original. That was fair enough. Then, to my great surprise, I heard that second question, and that is about page 4. Now, the real danger, this is intentional misconduct. They knew it. They had a break to think about it. They all sat here and discussed it. Mr. Harmon, Mr. Clark, Mr. Goldberg, and Ms. Clark. They sat there and they discussed it and they thought about it. And they thought, wouldn't this be terrific? Let's rehabilitate Mr. Fung. It'll look like this was an innocent mistake. And therefore, all the other contradictions caught on videotape, contradictions in his own testimony about this blood vial, they'll then be able to argue it was just an innocent mistake and he's telling the truth. And that's how they began their rehabilitation of this witness, trying to exploit their own misconduct and their own misrepresentations. There is no question, giving them every benefit of the doubt, that that was deliberate, it was intentional, and it was wrong. Now, this, I would submit to the court, is far worse than anything that occurred with respect to withholding tapes on Rosa Lopez. Because at least in that situation, first of all, I don't think that the court made a finding of intentional misconduct, or there was a basis of the record that it was as intentional as this, because this is clearly deliberate, not to turn it over before I had finished my cross-examination and then to try to use it to rehabilitate this witness's credibility. And it has a terrible effect because of the way that cross-examination ended and the jurors are looking at the documents. What they're trying to achieve here is the jury should forget all those other serious contradictions because of this point about page 4. Now, I'm assuming for the sake of argument that their claim is correct and this is in fact the original.
Good night, CJ.
So this is true misconduct. It is intentional. It is worse than the Rosa Lopez situation because at least in that instance, before cross-examining Rosa Lopez, the prosecution got an opportunity to listen to those tapes, to go out and interview witnesses, and the court extended them absolutely every opportunity so that they could not be damaged by this. In truth, there's no way to unring
That's
this
a
bell.
lie. That's a total lie.
It's
matter.
quite startling to
Doesn't
me,
matter.
Your Honor. At sidebar, when I raised this issue yesterday afternoon, Mr. Goldberg actually said, well, Mr. Scheck was trying to achieve a Perry Mason moment here. He was hoisted on his own petard. And he didn't say that, but words to that effect. And then he said, what Mr. Scheck should have done here is come to me and said, hey, what about that page 4 that, it's obviously not an original, and I should have tried to straighten all that out with him. And then he cited the fact that they had told us that that other page from the lab book wasn't an original, and then at the last moment turned over the original from Mr. Fung's notebook. Now, that's fairly incredible. That shows that they seem to have no idea of the rules, because the fact of the matter is that they're the ones that were representing to us all the way along the line that we had a set of originals, and they were not taking proper care to make sure those representations were accurate all the way through the point of cross-examination. And then it got fatally worse. After they knew that we had been misled and sandbagged by their false representations, they then intentionally, willfully went out to try to rehabilitate Mr. Fung's credibility, which they are desperate to rehabilitate at this point on a critical issue, by intentionally trying to exploit their own false representations. And they knew it, and they did it. So, Your Honor, that's why I've drafted a discovery sanction. I'm sorry?
A discovery sanctioned instruction.
Discovery sanctioned instruction that mirrors, I think, in a totally factual way, almost word for word, the instruction that you crafted with respect to the Rosa Lopez issue. And I think that this situation is far worse, and that I frankly think that the only remedy that really would undo the damage here is preclusion. That, in truth, is the only remedy. However, I recognize that the court may very well be reluctant to grant that remedy. And so I proposed this alternative instruction, because it seems to me that you must instruct this jury in no uncertain terms about the misconduct of these prosecutors here, about what they did, because it is, and about their efforts to rehabilitate Mr. Fung's credibility improperly, intentionally, that this was a violation of the law. And that my instruction mirrors precisely what you have previously issued.
Thank you, Counsel. Mr. Goldberg.
Thank you, Your Honor. Good morning.
Good morning.
I am outraged by counsel's representations and misrepresentations to this court, and I tried to take three deep breaths in advance, Your Honor, but I truly am outraged. And I'm sorry, but I'd like to discuss some things that probably are not directly pertinent to the issues before this court, because Mr. Scheck addressed them, and I think that they can't go unanswered. First of all, I'd like to set straight what happened on this question of the door entry issue, which is an entirely irrelevant point. They never requested those documents ever at any time. I never had any conversation with Mr. Scheck about them or any other member of the defense team at any time. What happened on that issue is I asked those documents of Greg Matheson for the purposes of being able to try to reconstruct events that happened on the 14th, the 15th, the 16th, and the evening of the 13th. I wanted them. And once I got them, I Xeroxed them and turned them over without request. Counsel never had any conversation with me about them thereafter. Now, what happened on that issue is Mr. Neufeld called Greg Matheson. He did not go through me, because they have a relationship with Mr. Matheson where they go to him directly, not even through the prosecution. And Mr. Neufeld apparently told Mr. Matheson that one of the pages was missing, and Mr. Matheson then caused that to be provided to them. But there was never any request, there was never any order for that item. Now, as to the next issue that he raised, which is the bindle, we believe, based on my conversations with Alan, that that bindle is perhaps in the court's custody. That has not yet been resolved. But I'd also like to point out that the prosecution cannot be blamed for any potential argument or any suggestion that perhaps the bindle that Mr. Lee created was lost, because when item number 6 came back, the control on 6 from Albany, it came back with a hair in it that was not there when it left. So we know some things happened to our evidence to change or alter the condition of that evidence in Albany by the defense experts, and we have photographic documentation of that. The next issue I'd like to raise in terms of misstatements by counsel is we discovered the existence of the real page 4 after cross-examination had been concluded, after counsel had represented several times to Your Honor, I can't remember whether it was on or off the record, that he was finished, that he had no further questions. And after I had requested a break and was given a break for the purposes of assembling my notes for redirect examination. That is the point in time, and the first point in time that we discovered it. And the way that I discovered it is because I knew that one other document, perhaps two other documents, were found in a similar manner, that they were found in Mr. Fung's notebook, and that he had the original, and that a copy was in the notebook that was supposed to contain the originals. I'd like to also address this issue of the Xeroxing of the crime scene identification checklist, which I believe happened in early May,
Well, Mr. Goldberg, let me,
in early March.
before you
excuse
move
me.
on to that, let me ask you a question about this discovery of the real page 4. At that time, do you believe you had an obligation, having now discovered that, knowing that the defense had made a request for a document examiner to examine each one of the pages of the crime scene checklist? And anytime you have a document examiner examine something like that, I mean, the implications are obvious. Don't you believe that you had an obligation upon making that discovery to immediately advise the court and counsel?
I did not believe so, Your Honor, and
Wow.
I'd like to address that in more detail, if I may, and very extensively. But with the court's permission, could I continue with the events that happened surrounding the Xeroxing of the crime scene
Right, so
identification
long as you
checklist?
understand that that's my primary concern.
Okay. As to the Xeroxing of the crime scene identification checklist, which actually Mr. Scheck and I did together, I'd just like to set the record straight on that. They told us that told me, Mr. Scheck told me, that his only reason for wanting to look at these originals, and I guess this must have been some kind of a subterfuge because they didn't want to let me know what their real intentions were. He told me
Be back in a few minutes, guys. Be good.
that they had written on their copies and that they didn't have any copies that were free of notations, and that they were kind of embarrassed about this, but were asking me to extend them the courtesy of Xeroxing those items, which I did not want to do because, as I have represented to the court, my Xeroxing skills are not the best. And it took us approximately 40 minutes to go through those documents, Mr. Scheck and I, and Xerox them, which I did as a matter of professional courtesy. What happened after that, after we were finished Xeroxing virtually all of the documents, is Mr. Scheck, who should win the prize of having Xeroxing skills that are even worse than my own, dumped out the entire volume of that original notes binder. And it was standing in a teepee fashion on the floor after we had gone through it. And it took us about 5 minutes to figure out how to undo that problem without getting the notes all out of order. And at that point, Mr. Scheck, well, about an hour or so later, asked me then to Xerox more documents pertaining to searches of vehicles. And naturally, I wasn't very eager to Xerox more documents at that time. And I said, I don't want to do it at that time. We resolved that issue. And then finally, I decided that I would provide them with Xeroxes. I'd just like the record to be straight as to the chronology of events, as to what happened during that incident. Now, Your Honor, I'd like to address this issue of page number 4, and the original versus the copy. First of all, I'd like to discuss it legally, which is something that Mr. Scheck didn't do. He made a lot of allegations, but he doesn't discuss the law. And I'd ask the court to go back to the law because ultimately this is a legal decision. 1054 of the Penal Code doesn't say anything about us providing an original document. It's not in there. The Constitution of the United States requires us to provide exculpatory evidence. What is page number 4? It is in front of Your Honor, I believe. It is a Xerox copy of a form. It doesn't have any writing on it. It doesn't have anything which would put any prosecutor or defense attorney, in my opinion, on notice that it is in any way relevant to this case, let alone exculpatory. So where is the legal obligation in any statute, in any case, in the Penal Code, under the United States Constitution, for us to have disclosed that document to begin with? It was disclosed, and we allowed them to Xerox and inspect them as a matter of professional courtesy. What happened, Your Honor, is that when they inspected these documents, they came to the conclusion, and I never looked at all of them and lined up the holes on the paper clips or the little holes at the top of the documents. I never examined them with that degree of care.
Have you examined the little, since you're such an expert at Xeroxing, have you examined all the little holes that represent staple holes that appear on Xerox copies?
I see that there are staple holes on the Xerox copies, Your Honor. I noticed that this morning. And I did not go through them with a degree of care to realize that the staple holes on the Xerox copies are Xeroxed and not actual holes. And I wouldn't have even thought of doing that. And as an advocate, quite frankly, I would not have thought of predicating a conspiracy theory based upon the existence or non-existence of staple holes on page 4. So no, I did not look at it. And I don't believe that Mr. Hodgman looked at it. I don't believe that Mr. Alan Yokelson looked at it with that degree of care, and we would not have. And I do not believe that we could have reasonably been asked to. Now, what happened is that after these documents were provided, counsel notified us that 2 documents were not original. One was L16. May I just refer to my binder, Your Honor?
Certainly. Mrs. Robinson? Excuse me, just a second.
Sorry, Your Honor. One was L16, which is the item that discusses on 6/14/94 certain items being released to criminalist Yamauchi. And the other item that they said was not an original was L31, which is the document that lists item numbers 20 through 35, most of them being stains that came out of the Bronco. They said was not an original. And I believe that we ultimately found originals on both of those items and provided them to the defense. They had a question document examiner look at them. They never notified us at any time or suggested to us that page number 4 was not an original. Upon closer inspection of that document, Your Honor, and especially with the aid of a question document examiner, it is obvious now to me that it does not have holes all the way through it. And they knew that. And with the relationship that Mr. Neufeld has with Mr. Matheson, he could have done what he has done on at least 2 or 3 other occasions and gotten on the phone with him or any of us and said, this is not an original, and the search would have been on as it was on the other 2 cases. He did not do that. Mr. Scheck did not do that. And I'm not faulting for them. I'm not telling you that they have any duty to do that. But they didn't. And they didn't do it for tactical reasons, and they are entitled to make that decision. And I don't know for sure whether I used the term hoisted on their own petard last night, but I'll use it now because that's what happened. They decided that they were going to predicate a theory that Mr. Fung was involved in a conspiracy on the existence or non-existence of staple holes. And they didn't want to tell us about it. And they didn't tell us about it. And we never made any representation specifically that we knew that that document was an original or that we had inspected that document. And we never would have even thought of doing so. And then after doing it, we did what any prosecutors would do in that circumstance and think, where can the original be? And they know we would have done that as well. And it was in the same place that the other document was, where we provided the defense with a copy instead of the original. And that is how we found it. Now, Mr. Scheck cited yesterday to the court what I called the I want to show it rule of evidence. When he was talking about wanting to show videotapes, he'd just say, I want to show it. And I said, I didn't see that in the evidence code. But I'd like to cite a lesser known provision of the penal code called the It's Just Too Bad rule. They made a tactical choice. If they were interested in the truth, if they were concerned about not proceeding on a theory that could be easily disproved, they knew how to do that. And in prior occasions, they had used those vehicles and those avenues to try to clarify when they knew they had a copy instead of an original. They could have done it this time, but they didn't. And the prosecution cannot be asked to pay the price for that tactical choice. It's a legitimate choice. I understand that they made it, but we cannot be asked to pay and should not be asked to pay. Now, I hate to get to the issue of sanctions, Your Honor, because we're saying there is no discovery violation. And we are saying that we did everything that a reasonably diligent prosecutor would do and more in accommodating and over-accommodating the defense. But you will recall that when the issue of sanctions came up yesterday, as to the defense tapes that were not displayed, I said, I can't ask for preclusion, I can't ask for an instruction, I can't ask for anything except some time to review the tapes. Even though it was clear that counsel was grandstanding in the way that they had disclosed these tapes. Because the sanction, if any, must fit the harm that has been done, if any. And the only harm that has been done here is that their tactical decision didn't work. And the remedy is nothing. It is to do nothing. And that's assuming there was a discovery violation, which we certainly don't concede.
All right, well, why don't we go back then to my question to you?
And your question was, did we have a duty to bring it to the court's and counsel's attention as soon as we found it?
Correct.
And we believed that we did not. We discussed it, and we felt it was clear that they had made a tactical choice. It's clear that they could have brought it to our attention. It's clear that we were entitled to introduce this. It's clear that we had no obligation of the law, under the law to produce it. And at that time, at that hour, we believed we did not have an obligation.
Well, let me ask you this. Since I did make the order that the originals be produced for document examination, doesn't that include page 4 as soon as it's discovered?
And it was produced. I mean, it was produced in court.
Well, it was produced for I ordered it produced for the purpose of document examination by the defense, though. So didn't that place an obligation upon the prosecution to then produce that item?
I didn't hear the end of the court's question.
Didn't that place upon you at any point when you discovered that you had an original in your possession to notify the court, at least under 1054.7?
1054.7 is in-camera hearings.
That's correct. In other words, if you felt you discovered something that there was some question as to whether or not it should be turned over, then you have the right to ask the court to make that determination ex parte.
But Your Honor, that is true. We can have a request an ex parte hearing whenever we feel we have information that we don't want to turn over. But we did want to turn this over. I mean, there's no question about that, that as soon as we found it, we wanted to turn it over. And we'd love the defense to have the opportunity to inspect it as much as they'd like to inspect it, and they will have the opportunity to do so. So we would not have requested an in-camera hearing under 1054.7 to say to Your Honor, we want to hold this back, because that was not our intent. And what I would ask the court is to think about also the court's order that the defense show us videotapes in advance, which has been repeatedly breached. And what sanction has been imposed? The sanction that's been imposed is the court has given us time, and we've been thankful for it, to look at those videotapes, because a lot of the times that's the only appropriate sanction that we can ask for. And that's all we have asked for. May I just have one moment? So what we would ask in the court to do is, if the court's going to impose any sanction, that the court be even-handed, and that the sanction that would be imposed, and we're not saying that any is warranted because we're not seeing that there's any discovery violation, is to give the defense more time to look at it, as the court gave us more time to look at the videotapes. The court must be even-handed, and we request Your Honor to do so, and I know you want to do so, in the way that the court makes its rulings. And I think that, if anything, this is comparable, but in our case, far less clear, because there was nothing that reasonably would have put us on notice. And I really feel a little bit reluctant to make this last argument, but in light of Mr. Scheck's argument, I don't think I have any other choice. And that is that when these items were being viewed by counsel, he said, well, we have notes of watching them view it and so on, as if there was something improper. Actually, what happened is I was in the room. It was actually the kitchen area and the library area of the Scientific Investigations Division on a Saturday. See, we opened up the laboratory for them on a Saturday so that they could be there. Something that we do for every defendant who's on trial. And I was present when Mr. Scheck was viewing the notes. And I was present because I wanted to make sure that nothing happened to alter or change the condition of our original notes. And that was one of the conditions that we felt that we wanted to put on them looking at them. I was sitting at the extreme other end of a table that was approximately the same size as both tables that are in Your Honor's courtroom, in what I describe as a library/kitchen area of the lab, because I did not want to look over their shoulders, and I felt that my mere presence would be a sufficient deterrent. But I don't know everything that happened, and I wasn't watching them every moment when they looked at those notes. I don't think that would have been appropriate for me to have done. But if Mr. Scheck's Xeroxing skills are any indication of his ability to perhaps confuse documents, we don't know for sure what happened.
All right. Mr. Goldberg, I don't mean to cut you off, but I'm really not interested in those activities.
Okay.
All right.
And I'd also like to point out, and as I said, I apologize, and I apologize to counsel, but we have to sort out what happened here and how it happened. And there are a lot of facts that we just don't know. And that's all I'm pointing out, Your Honor. And I apologize to Mr. Scheck. I apologize to you for bringing these facts out at all. And I'd like to also point out that Mr. Scheck did have the notebook throughout the court session. So trying to reconstruct how this item number 4 happened isn't something that we could do with any degree of precision and certainty. And again, Your Honor, I don't like this kind of advocacy, and I'm not trying to cast any aspersions. All we're trying to say is that we can't reconstruct how those events occurred.
Thank you. Any brief response, Mr. Scheck?
Your Honor,
Yeah, would you focus your comment on the obligation to disclose upon discovery? That's the only thing I'm really interested in.
I understand. Your Honor, they just admitted it, didn't they? They said that they discussed it. They all sat there and discussed it and decided that they had no obligation. That's fairly extraordinary. Your Honor, Mr. Goldberg seems to think that when you issue a court order to produce the original documents for us to look at with the document examiner, that he was just doing us a professional courtesy. That's a court order to produce the originals. Representations were made that these were the originals. Then they got notice that there were some problems, and perhaps some of the originals might have been in Mr. Fung's notebook, and not produced to us. Now, let's be very clear about those facts. Mr. Hodgman and Mr. Yokelson said, here are two documents that we know are not originals. The others that you're looking at are originals. These aren't, and we're still looking for them. And then they find them, apparently, in Mr. Fung's notebook. And that is more than enough notice that maybe this is going on, and maybe all the pages that they didn't give us in the first place were originals, and that we're in a perilous situation where we may be relying on something that was not originals. And obviously, they had an obligation to make sure that they were giving us what they claimed to be originals in the first instance. And anybody could have seen from looking at those, if they'd examined them carefully, that there was certainly an absence of staple holes. And incidentally, Your Honor, in terms of the Xerox, there's also trash marks from the Xerox machines all over those pages. So I'm not sure it's entirely clear those are staple holes versus trash marks. But the point is,
Well, if you look at it, they seem to line up in the same
well, no,
places.
but those were also Xerox trash marks, and they don't necessarily accord with all the staple holes. But that's besides the point, isn't it? The
Well,
point
that's
is,
for the fact finder to determine only.
well, no, Your Honor, let's say that that is the original. Let's say that that is the original. The point here is that Mr. Fung has been severely impeached on exactly how the,
No, Mr. Scheck, the point is, did the prosecution have an obligation upon discovering that they had it in their possession to notify you and the court that they had it?
yes.
That's the only thing I'm.
Well,
really-
Your Honor, there's no question that under 1054.1, they must disclose all relevant real evidence obtained as part of the investigation. We asked for the originals. The court ordered them to turn over the originals. We examined the originals. Then they were on notice that they may not have given us all the originals. They took no steps. And then when they realized that they had misrepresented to us the fact that they had turned over all the originals and we relied on it, and I had not yet stood up and said no further questions because I didn't do that until after the break, they sat there, they discussed it.
After I reminded you to do that.
That's right. But it's clear. It's clear. And they sat there, they discussed it, and they actually decided intentionally that they could go about rehabilitating the witness because it would be helpful in order to make the jury think that all the other contradictions were just innocent mistakes, that they were going to do it, even though they had represented to this court and to counsel all the way along the line that these were originals that we had. They didn't bring it out so that perhaps I could try to undo this damage myself in some fashion with appropriate stipulations that I had been misled, because that's exactly what happened, and they did it intentionally. And Your Honor, I know you don't want to hear these things, but I'm trying to be as careful and as factual with the record as I can, because there's an implication in Mr. Goldberg's remark. I will readily admit to being a klutz. And when I said yes, no, you have to hear this.
No, I don't have to hear it.
Well, no, Your Honor,
Mr. Scheck.
he's just wrong in his factual statements.
No, Mr.
There-
Scheck,
the notes
no,
show-
Wait,
I didn't Xerox those field notes.
Mr. Scheck.
Okay.
I'm sure it's interesting to hear, but it's
Yeah.
not really relevant to the decision I have to make.
Fine. It's just, all right. What he said wasn't accurate, and I can prove it. The point is this, that everything that I've said in terms of giving them a reasonable benefit of the doubt, every factual innocence, every factual assumption,
Well, counsel.
Yeah.
Mr. Goldberg indicated that upon discovering it, he discussed it with his co-counsel, and there was a decision not to disclose it.
yes,
Is there anything more you need to argue?
I really don't think so. I think it's it's intentional misconduct.
All right, the court is concerned about this situation because I did order the production of these original documents. And I accept the representation that the initial production of what turns out to be a photocopy of the real page 4, that the failure to disclose that or to keep it with the originals was inadvertent. And in examining the two items, both what was originally, let's see, we have to be precise in our terminology here, the original page 4 that was disclosed as and purported to be an original, and then the late discovered original. In examining the two forms, the court finds that they are identical except for, of course, Xeroxing of one of them, that there is no information contained. They are essentially blank forms. So as far as the content of the form itself, there's no Brady content here. Therefore, the failure to disclose this is inadvertent, and it's a no harm, no foul. The other issue, however, is the originality of the form itself. There was a discovery issue as to that. The court did order its disclosure. I find that the failure to disclose both to the court and to defense counsel the discovery of the original document, page 4, have been intentional and should have been done prior to the conclusion of the cross-examination by Mr. Scheck. And the original, the field notes are Defense Exhibit 1107, is that correct?
Yes, sir.
Your Honor, could the court perhaps look in the record to see whether Mr. Scheck said no further questions before we found it? Because I'm told that that may be the case, that he actually formally said that.
I did examine the record yesterday. What he said was, after these two items, I have no further questions. And we were at that time exhibiting the documents to the jury.
Can we double check on that?
Absolutely.
Because
Be my
I'm
guest.
told that-
I'm not, I was there. We didn't find this until the confidentiality was concluded. Until this-
Ms. Clark, Ms. Clark,
Your Honor, we can't
fine,
brief
wait,
you on
Ms.
that.
Clark. I'll have Mrs. Robertson get the transcript from yesterday. On approach, let me give you the court's transcript from yesterday, see if you can find that location. But I recollect specifically checking it myself. All right, do you want to read it to me?
I'm reading from page 22,781. May I just have one moment, Your Honor?
Certainly.
Sorry. Your Honor, I'm looking at page 22,781.
Yes.
The court is speaking. All right, Deputy Russell, would you return that document to Mr. Scheck? All right, the record should reflect that each of the jurors has had an opportunity, including the alternates, has had the opportunity to review the Defense Exhibit 1107. Mr. Scheck. Mr. Scheck. Yes, Your Honor. I just would mark page 4 of this crime scene checklist 1107B. I have no further questions. Court. All right. And then Your Honor continues, ladies and gentlemen, I'm going to take a 15-minute break at this time, and so on.
Prior to that, go back to the second couple pages before that.
To the what?
If you recall, we had, when you were making your request for a break between the cross-examination conclusion and the beginning of your redirect, I asked Mr. Scheck, do you have anything else? And he said something to the effect, I thought I said no further questions. And my recollection is I heard him say, after these two things, I will have no further questions.
Well, you see, the problem is, Your Honor, I don't know if that was recorded because
No, well, it's in the transcript.
what?
Flip back a couple pages. That's the benefit of having the real-time recording because I was anxious to see whether or not Mr. Scheck was really done.
Well, it must have been much earlier if it occurred. Does Your Honor recall whether this happened?
Oh, why don't you hand me the transcript?
Right,
Maybe I can
okay.
find it. It's at page 22776 at line 21. Mr. Scheck, Your Honor, I would like to do two more things and then I'm finished questioning this witness. That's the passage that I'm referring to at 22776.
May I have the opportunity just to address this information since we didn't have that in our first.
Briefly.
I don't under, the reference that the court just read happened, I believe, prior to the exhibits being shown the witness. Item number
no,
4.
that's
Page number 4.
that was
Or what?
after.
But it wasn't after he had concluded examining the witness, because I believe there was still examination on those exhibits, fairly extensive examination, as I recall, between then and the time that he said.
No, there were no further questions put to the witness.
Okay, but I still don't understand the significance of that particular passage in light of the passage where Mr. Scheck did say on the record prior to the break that he had rested. I mean, that is the posture that we were in at that time. He had completed his examination.
Okay.
And that's what we believe to be significant here. Now, if the court,
Right. No, I agree with you that that particular passage of the transcript is not particularly elucidating one way or the other. The issue is, once you've discovered it, did you have an obligation to disclose it both to the court and counsel?
then after they have rested, if the court is saying we had an obligation, and you know, then you have to go back legally to what our obligations are at that point. At that point,
We've already discussed this part of it.
Okay, all right, but at that particular moment in time, he's already concluded his entire cross-examination. He's already said that Mr. Fung is conspiring based upon the non-existence of staple holes. So if we can try to back ourselves up to that moment in time, what is going to be done at that point in time? What is it exculpatory to the defendant if we say, Your Honor, we have this piece of evidence? Is that exculpatory
No,
evidence?
counsel, you're arguing all that, the other issues. I was only interested in the.
But what I'm trying to get at, Your Honor, is if we back up to that precise moment in time, what would have been done from then forward? I mean, let's say we had come up to the court and said, Your Honor, you know, we have this document and it's this.
Do you agree that's what should have been done? Do we agree on that point?
Well, if I have to agree to that in order to win, but we discussed it, with all the, Your Honor, I just don't want to get into a argument over the court with something if Your Honor has already made up your mind on it. We discussed it. We felt that he had rested. We felt that there wasn't anything that could have been done at that point in order for the defense to erase what they had done, or that the court would give them the opportunity. There wasn't anything that they could have learned by examining documents more carefully. So if you back up to that moment in time, don't we have to try to articulate from that point forward what would have been done had we come up to the court and said, Your Honor, we found this item of evidence. Would the court allowed him to reopen? And then if he reopened, what would have he done?
Well,
what would if he
Court
requested
has
him?
been known to allow counsel to reopen.
Okay, but then if the defense is asking for a sanction, don't they have to show where the harm is? In order to articulate the harm, don't we have to back ourselves up to that precise moment in time and run forward and try to replay what would have occurred had it been done differently by the prosecution?
Well, don't you think the defense has just sort of been embarrassed that it set up a scenario where they accused Mr. Fung of having destroyed an important document that might document certain important dates and times, and left that impression with the jury, which is totally empty if this is the real page 4.
I don't know whether they're embarrassed or not, because they've come up with so many other things that they've tried to use to shoot down our case that have been very easily disproved and dispatched. But Your Honor, the point that I made is it's a tactical choice. And are we accountable for the tactical choice?
Right.
I'd ask the court to make a finding as to whether or not the defense engaged in a tactical choice here.
Oh, no, obviously they did.
They
But
did.
counsel, here's the problem. I ordered its production. That's the foundation for all of this discussion. I ordered its production. It wasn't produced. It should have
You know,
been.
Mr. Cochran, is continually talking and making comments to me off the record. Well, he's saying it in a voice loud enough so that it's.
Well, counsel, I'm hearing commentary from both sides of the bench. All right, thank you.
Yeah, Mr. Hodges is here to address the discovery order that's came out of the court concerning the original. And the truth of the matter is, they had the defense wanted to get at the truth and get that document page 4 original. And
Mr.
they told
Hodgman?
us so. They failed to. Mr. Hodgman is here to address the fact that they never requested that original. And what has happened here is they are paying for their own tactical choice. If they wanted to find
Ms.
out.
Clark, are
whether
you
it exists
addressing
or
this
not,
issue, or is it
defense-
Mr. Goldberg?
Mr. Hodgman is here to address the discovery matter.
Thank you. Mr. Hodgman. You're on.
And good morning, Your Honor. I understand my name has been taken in vain this morning, so I thought I would come down to see if I can give any help in enlightening the court. And as the court has asked, I will offer to the court what I know about the situation. First of all, in terms of my direct contact with the question document examination, I had asked Mr. Yolkelson of our office to handle that more directly. I was a participant in some of the communications with counsel in terms of setting that up, as well as with Mr. Matheson and SID. And some
Well,
of what
just-
I'm about to relate to the court is
Mr.
based
Hodgman,
upon.
let me just cut through all of that, because I know that you and Mr. Yochelson were involved in the discovery discussions between the parties, but the issue is you acknowledge that the court had ordered the production of the original documents.
Yes, and we made every effort to turn over those documents. In fact, counsel, Mr. Neufeld, had alerted us to the fact that there was apparently, well, actually, my recollection may be a little vague on this. I think we alerted Mr. Neufeld that there was one original that we couldn't locate, and Mr. Matheson had informed me about that.
Do you recall which document that was?
I recall it as being L16/31, which at the time we believed was two sides of the same single page. I think in the interim, we've determined that those are in fact two pages.
We agree that that comports with our recollection.
And I see the affirmative nodding of heads from defense counsel, so that appears to be the case. And with that, I know Mr. Matheson undertook to find that particular page, that missing page, which subsequently, and I'm unsure as to the exact point in time, we did. And all of this was in the spirit, Your Honor, and I think Mr. Neufeld, with whom I was communicating primarily on this, and I know Mr. Yochelson was having additional conversations, was in the spirit of trying to comply fully, openly, forthrightly with the court's order. Until yesterday afternoon, I never knew about this page 4, which Mr. Scheck was utilizing in the course of his cross-examination. As far as the discovery of page 4, it appears that it was discovered as represented. I can't shed any new facts on that, but it appears into the fact that it was not turned over was certainly inadvertent, as the court has pointed out. And as far as the manner of disclosure, if counsel was aware of it, I would think if had they alerted us, we would have made efforts, in fact, gone to great pains to attempt to sort out the situation for the defense, for the court, for purposes of getting at the truth. We have no interest in hiding the truth, Your Honor. And as I'm reminded from Ms. Clark, and I can speak for Mr. Yokelson on this as well, we were never notified that that particular page, this page 4, was missing.
Well,
Had we,
Counsel, I've already made a finding that the failure to locate the original page 4 up until and including yesterday was inadvertent. And then examining the 2 documents, there's nothing on it. So there's obviously no Brady content. There couldn't be because it's just a blank form. The issue being, should it have been disclosed?
You know what I'm going to say. Everybody knows what I'm going to say. The defense has done this the whole time. The whole time, the defense has done this exact same thing. And then judge has just been like, okay, prosecutor, here, just take some time to watch this video that they didn't disclose to you. Take some time now to watch this video. Take some time now to look at Rosa Lopez's stuff that they hid and didn't disclose. You just take some time now.
As soon as it was discovered that there was an original, and it was the linchpin of an interesting argument made by the defense,
and there
rather
was
than
nothing
springing it
different.
on the witness to the surprise of the defense
But there was nothing different. It was the same piece of paper.
during the first phase of redirect.
and the only reason I bring the point up, Your Honor, is with regard to the issue raised by Mr. Goldberg, which I believe is a valid issue about tactical choice. Had we been notified, had a phone call been made, we would have made.
But isn't the foundation of everything the court's order to produce?
Yes, and the court did in fact raise the court order. All I'm saying is, had we known that that particular original had not been produced, we would have gone to great pains, great efforts to find it for them so that they could have had it, but we never got that notification.
Thank you, Mr. Hedgeman. All right, I find that the failure to immediately disclose to the court, to counsel, was a violation of the court's order, and I'm going to instruct the jury as to that. All right, let's have the jurors.
That's the sanction?
The instruction is going to be before you do.
I've heard your request. I've heard their request. I don't think preclusion is, I forgot to also add, I don't believe preclusion is an appropriate remedy,
We would hear other issues before the jury comes out.
such as,
Well, we would like an instruction to the jury as to the videotape, that they intentionally did not disclose that videotape to us yesterday, a series of videotapes at the Rockingham location. In identical words to whatever the court is going to now.
Yesterday.
And we think we're entitled to that. We think this is
Keyword there is yesterday, which is not for us. Yesterday they did it. Yesterday the defense did it.
a completely analogous situation. I did not ask for it at the time because, quite frankly, I was thinking no harm, no foul, which is the way I felt this should be resolved. But we would ask for that kind of admonition. Second issue is the phenolphthalein issue.
all right, what is the likelihood we'll get the phenolphthalein today on your redirect?
It's fairly likely.
Yeah, we have some additional points I thought we'd like to present on that issue.
Which is why I tried to start at 8:30 this morning. All right, for your information, the court will instruct as follows. In this case, in a pretrial motion, the court ordered the production of the original field notes, Defense Exhibit 1107, for the purpose of examining these items by a question documents examiner. At the end of the defense cross-examination of Mr. Fung, the prosecution discovered in its possession what purports to be the original page 4 of Defense Exhibit 1107. The prosecution should have immediately disclosed this discovery to both the court and the defense counsel. The failure to immediately disclose was a violation of this court's order. That will be the court's instruction. All right,
I really thought that they were going to say, that he was going to say, there are no differences between the original and the copy.
inviting argument on that,
Oh,
counsel.
Your Honor, may I just make a record then?
You've made your record, counsel,
Well-
more than adequately. I've allowed you to argue more than an hour today.
No, I
No, you,
don't think I took up a lot of that.
no, this argument has gone way beyond its need. I've allowed both sides adequate record making. I've made my ruling.
Well, Your Honor,
Mr. Scheck, last time, I've made my ruling. All right,
the proposed instruction is that we submit to the court.
it's here. It's in front of me. I've read it. I've considered
Make
it.
Part of the record.
Absolutely. You filed it, I take it. Yes, all right.
Court refusing to admonish the jury concerning the defense vocal refusal of disobedience of the court order to advise us ahead of time about the videotapes.
Counsel, I haven't gotten to the issue yet.
I have a question.
Let me see counsel at the sidebar without the.
Spicy day. We're having a spicy OJ day, guys. OJ with Tabasco today.
All right, we change court reporters. All right, Ms. Clark, you had a request of the court regarding sanctions.
Yes, Your Honor, I did. People have made a request with this court that the jury be admonished concerning the defense willful withholding of the videotapes and their production and notice to the prosecution in violation of the court's order. And the court's made this order a number of times, requiring that both sides
I meant
apprise
as
the
far
other.
as timing.
And as far as timing, and my request is that if the court is inclined to give an admonition concerning the prosecution's discovery issue on page 4, that it withhold that admonition until we resolve the admonition concerning sanctions against the defense for their willful refusal to obey the court's order concerning production of the videotapes, and that the admonitions be given at the same time, if any admonition is to be given at all. And so, since the court has indicated that it is inclined to resolve the issue of defense, an admonition to the jury concerning the defense violation of the court's order concerning production of the videotapes until 4:30 Monday.
Slow down.
How you doing, Janet? She hasn't thrown anything yet.
Court
I'm
reporter
doing
is
okay.
going cross-eyed on me.
Who's smoking? I know. They usually throw things at me. That's my first cue. I would
No, they
ask
send
that,
me messages here.
did you? That we resolve all of those issues at 4:30 on Monday, and the court give all admonitions at the same time. And that's what I'd ask the court to do at this time.
Mr. Carmen.
Excuse me. Let me also remind the court, I'm reminded by Mr. Darden appropriately that the defense violation of the court's order resulted in a 2.5-hour delay yesterday because they did not advise us.
I was the cause of a lot of that.
But no, but you know something, they were really the cause of it, Your Honor. That's the truth. You know, it's very gracious of the court to take some responsibility, but it's not the court's responsibility. The defense should have told us about those
All
tapes.
right,
and
we're
failed
arguing
to.
the issue at this point.
Yeah.
The only issue is whether or not I should withhold the sanction instruction now.
Mhm.
Mr. Carmen. Thank you, guys.
Thank you very kindly, Your Honor, and I appreciate the opportunity, and I'll be brief, Your Honor. Again, as you so often said, they're comparing apples and oranges, Your Honor. This is a situation, a violation that occurred right with this jury yesterday that needs to be corrected. The court could have very easily and would have probably allowed counsel to reopen to carry this thing. They made an intentional decision out of the mouth of Mr. Goldberg, so I don't want to relabor and re-argue that. So this needs to be dealt with right now. With regard to that, Your Honor, and the sanctions are Your Honor's business. You've had under submission now for almost 2 weeks additional sanctions regarding the prosecution. We're not asking you to do that, and we have this rule of one lawyer talking per side, which consistently is violated by the other side there. And, you know, we tried not to do that, but I feel
Right.
constrained at least to
Not
point out,
always successfully.
and certainly, Your Honor, when we address you, I think you can point out that we address you in a respectful manner, not in a hostile manner, standing up when you tell us to be quiet, we sit down and do that. And I think that should work for both sides. And I hope and I pledge to you, we're going to do that from our side. But the point is, this is a violation which the prosecution has been caught red-handed in today, Your Honor. Mr. Goldberg, to his credit, stood here and said, all of them, it's not just Mr. Goldberg, all of them sat here and made a conscious decision to violate your court order. That's a different situation.
He
When
didn't name Mr. Darden.
Well, he said, no, he didn't name Mr. so he said, excuse me, well, excluding Mr. Darden, he said all the rest of them, including Mr. Harmon,
Does that
Clark, all the rest of
Is
them,
that
except
better?
there,
He
including
didn't
Mr.
cite Ms. Martinez either.
Well, we'll exclude Mr. Martinez and Mr. Darden, but the rest of them made a decision, and we saw them in court discussing it yesterday. The point is, Your Honor, this is something that needs to be dealt with right away and right now. With regard to and we're more than happy to have you look at the videotapes. What you're going to find is they had all of those videotapes, with the exception of one that came here, Your Honor. It was delivered in this courtroom, and we gave it to them immediately.
Hey,
There's no violation.
Kelly.
And what happened was, unlike this situation where they made a tactical decision for an advantage and
Thank
then
you,
try to do this in front of the
Kelly.
jury, they saw these videotapes. They went back in your chambers. You gave them the chambers for all that time. If we got a
We're
videotape.
arguing the motion at this point.
Yes, I don't want to argue, but I think we welcome that. But this is a separate situation, as you so correctly pointed out in the past, and I'd ask you to proceed. You know, when they're wrong, and we have to deal with that as we've done in the past. Let's move this on. We have 12 people, or well, we have 19 people now, 18 people back there. We've been
18.
waiting all this time, 18, and I hope it doesn't get any less. But we have 18 people back there who have a right to proceed, and we have a right to have this corrected today. The wrong was yesterday. They should have corrected it yesterday. They made a decision, and they can't hide behind the fact they want to bring up something on us. We're professionals. We should go forward at this point and deal with it. We welcome any discussion, because you're going to find there was no violation regarding these tapes. They had all the tapes. They should watch them. And then when we got the new tape, he then showed it to them. You let them have their chambers for that reason. So I'd ask you to proceed with that, Your Honor, and I thank you very kindly.
All right, thank you, counsel. All right, I'm sorry.
May I just point out one thing? This one. The situation is identical. It's a tactical decision that the defense made to brandish a videotape before the jury in a grandstanding fashion in violation of the court's order requiring us to object in front of the jury. No different. It's a tactical decision that they made deliberately with knowledge, repeated knowledge.
All right,
of
we're
the
arguing
court's
the
order.
motion again. The
Okay.
issue is, do I do all the sanctions at one time,
That's why.
or do I do them piecemeal?
But that's why I think the sanctions should be resolved all at the same time, because it is the same issue and the same conduct that we're being accused of. And I don't think it's the same. I don't think that we are in violation, but clearly they were. And they did it on purpose.
All right, thank you, counsel.
You just can't stand letting me have the last word. It's clear.
Your Honor,
This has got to end at some
no,
point.
it is. This is going to end, hopefully, Your Honor. Your Honor, with regard, Your Honor, to the tapes, nothing was brandished before the jury. They had already seen those videotapes, and the court excluded the jury. And we looked at the tapes. They had every reason. They called Van Adder over here. They had people come down. This is a different situation, Your Honor. We acted appropriately, Mr.
No, we're arguing the motion again.
Yes, but I mean, they're separate things, Your Honor. I want you see that. I mean, it's a separate thing. It's apples and oranges, or apples and watermelons. It's different.
It's different because yours is worse, sir.
All right, we
Worse.
do have other sanctions matters on, is my recollection. The Harmon sanctions motion. Ms. Clark, are you going to file any papers on the videotape? All right, file it by Tuesday morning. All right, all further sanctions issues will be taken up Wednesday afternoon, April 19, 4 o'clock. All right, let's have the jury, please.
No, is he still going to read that? No, Judge, come on. My God.
Matters in the half hour before we were scheduled to start at 9 o'clock. As you can see, our half hour turned into a little longer than that, so I apologize to you. That's the bad news. The good news is that, as you know, the staff has been arranging for you periodically different entertainment, and I think you'll be very happy with the entertainment that we'll provide for you this weekend. It'll be something, special. I mean, we've done some special things for you, and I know you appreciate that, and we appreciate you bearing with us, so I'll try to make up to you for it. Just keep that in mind. I apologize to you. I see your smiles. You understand we have these problems, and I thank you deeply for your indulgence in these matters. All right, do we have Mr. Fung available? All right, Mr. Fung, would you resume the witness stand, please? All right, good morning again, Mr. Fung. You reminded you were still under oath, sir. Mr. Goldberg.
Thank you. Your Honor, I'd like to put People's 182 up on the Elmo, if I may. Could we get a close-up of the upper left-hand corner? Mr. Fung, when you examined this document briefly last night, did you see a variety of paperclip holes in that document?
Staple holes, yes.
Staple holes, sorry. And also what would appear to just be some black artifact little dots.
Yes.
And could we, perhaps using the telestrator, see if we can mark the various paperclip holes that you saw in this document? Maybe you can direct us.
Down.
Mr. Goldberg, is this really necessary for him to look at telestrate all of the staples?
I'd just like to get some of them. Maybe we'll do 3 or 4 if we can. There are a number of them there, and I just want to show the jurors.
Well, we have the document here. We can show it to them. Don't you think it'd be easier for them to look at it?
I'd like to do that too, if I may do both.
All right. It seemed to me that they're looking at the document. There appear to be.
Okay, down, over to your left, a little bit more, there. Down. It's hard to make out on the screen here.
Okay, can you see them on the larger screen?
Not from this angle. Down from there and to your right and down a little bit more. There's one there. It appears to be there. And one more.
Let's see if we can get another one, if you can see one, if the resolution's good enough on your screen, Mr. Fung.
Right next to the one on the bottom, there's one at the 2 o'clock position. Right there.
And now perhaps we could put the next document.
Donna, thank you so much for the $10 PayPal. I appreciate it. Thank you.
It's 1107B, that's exhibit on the illustrator. And Mr. Fung, if you see the way that this is positioned on the telestrator, do there appear to be little black Xerox dots that corresponded to some of the actual holes that were on the other exhibit, the real page 4?
Approximately, yes.
And is that what you were referring to when you were saying that you did a preliminary
Those are
evaluation of the document?
That's just one of the characteristics that I looked at, but yes.
What were any of the other characteristics you looked at?
I looked at the folds in the upper left-hand corner of the document and the holes, paper punch holes at the side of the left-hand margin.
Okay, Your Honor, with the court's permission, I'd like to pass these 2 documents through the jury.
While the documents are being passed to the jury, maybe take the opportunity for a brief sidebar.
Yes.
I heard some people even swear at their cats in Zoom hearings by accident.
Was any part of that exhibit ever filled out?
No,
And the portion that says time leaving crime scene, let me just put that up. The portion that says time leaving crime scene was not filled out.
no, it was not.
It was just so funny, Monkey. It was so funny. Oh my God.
Just a moment. Your Honor, next I'd like to take a look at the Defense Exhibit 1107 with item number 17, 18, and 19. Your Honor, do the lights need to be dimmed in the courtroom for us to get resolution, better resolution on this? Sir,
We would love
with
to get
respect to this
resolution,
exhibit,
please.
can you tell us again how this exhibit came into being?
On the morning of June 14th, Ms. Mazzola wrote down items of evidence which had not been previously written down in our evidence collection checklist.
Okay. And is this an official form of the Los Angeles Police Department, what we're looking at right now?
No,
Is this a document that has, that's two-sided?
no, it's not.
All right. So in the ordinary course of the crime lab's business, when you're documenting items that have come from a crime scene, are you supposed to use this kind of form?
No,
Or this just a blank sheet of paper?
no.
And then at some point, you became aware that Ms. Mazzola had written it on this piece of paper?
Yes,
What did you tell her at that point?
I told her to place this information on an evidence report form that's included with the crime scene checklist.
All right. And could you have simply told Ms. Mazzola, look, this is sort of a Mickey Mouse thing here?
Sustained. Phrase question.
Could you have told Ms. Mazzola simply to throw this away?
Sustained. Phrase question.
Under the policies of the crime lab, was there any obligation for you to save this document?
As it was written there, no.
Was there any custom within the crime lab that you're aware of that required you to save this document?
No.
would there have been any rule or procedure that would have been violated had you simply told Ms. Mazzola, throw it out and write a new one on an official form?
No.
So did you make a decision to preserve this document
Yes.
and maintain this document?
Yes.
And did you know full well that when you made that decision, copies of this document and eventually the original would be available to the defense and discovery?
Sustained, rephrase the question.
Sir, are you familiar with the procedures of discovery?
Some of them, yes.
And are you aware that the defense is entitled to copies of documents,
Yes.
including this one?
Yes.
Objection?
I have an objection to that question with respect to matters that have been discussed.
Overruled. Proceed.
So, Mr. Fung, if I understand your testimony, is the evidence that the defense has here that they claim shows some sort of conspiracy on your part, does it exist simply because you maintained it and preserved it?
Sustained. Rephrase the question.
Thank you. You maintained this
Yes, I did.
and preserved it.
Yes, I did.
Overruled. You can cross-examine on that. counsel.
There's an issue here. I think that
With the court reporter, please.
He shouldn't have said that. He was wrong. I'm just watching Shrek. I keep saying Shrek. I can't help it. I can't help it.
All right, are we done with this exhibit, Mr. Goldberg?
Yes, Your Honor. And now, I just want to approach this, if I may, with this document, just ask him one more question.
One more.
Sir, with respect to this item number 1107, what is the on the front of the form?
The front is the field notes portion.
I'd like to see the other document that's part of 1107. It's the page that has items 17, 18, and 19 written in it.
one, please. One, please.
Sir, and what is this form again?
This is an evidence collection report.
And is this the form that Andrea Mazzola created after you told her that you didn't want the items on that blank sheet of paper that's on the reverse of the field notes?
Yes.
And when you first saw it, what were the order of the items?
I'm going to refer to my copy. The order of items was that 17 was in the top box where 18 is. 18 was next to it or below it, and 19 followed it.
And how was that problem dealt with? What did you do about that?
I erased 17 and 18 and changed the numbers.
Oh, I'm sorry. I think monitored up here for jurors 1 and 2 is. Do we have it on? Mr. Mr. Fairlawn? Where's Ms. Fitzpatrick? Sit down. All right, thank you.
Now,
Mr.
Mr. Fung, if you write out a report in the crime lab and you make a mistake on that report, or there's something on it that you want to change, is there any rule that says that you can't simply, if you're in the process of creating the document, throw it away and start all over again?
There's no rule to that, no.
Did you ask Andrea Mazzola to do that with respect to this document?
No.
So did you decide to maintain this document?
Yes.
As a criminalist 3, could have you said, would have it been within your power to have said to Andrea Mazzola,
Finish the question, but it sounds like it's leading.
do you have the authority as a criminalist 3 to tell a criminalist 1, clean up this document, write out a new one?
Yes, I do.
Did you do that?
No.
Now, you said that you had no recollection of talking to, thank you. No recollection of talking to criminalist Mazzola specifically about the circumstances under which you got the blood vial. Is that correct?
That's correct.
And why was it that you, well, did you have a recollection of talking to her about things like the circumstances of collecting the blood on the trail at Bundy?
No.
Well, do you believe that, do you have a recollection of talking to Ms. Mazzola about collecting items on the trail at Bundy?
Yes.
Okay, what about at Rockingham?
Yes.
What about the glove and the cap at Bundy?
Just briefly.
Okay. And why did you talk about those items but not the vial? Or why is it that you remember?
Objection is to time when these conversations took place. These questions are vague.
Sustained.
You said that you had a conversation that was at some point after the Griffin hearing with Ms. Mazzola.
Yes.
That's vague to the jury, too.
Well, oh yeah, that's true. Yeah, I think it was. Perhaps we could later on have that, the court takes judicial notice of that. Sir, was there a hearing in which you were questioned by the defense about various aspects of things you did on the 13th in collecting evidence with Ms. Mazzola?
Yes.
All right. And at some point after that hearing, did you have a conversation where you tried to determine who specifically picked up certain items?
Yes.
And you have a recollection of talking to her in that conversation about the trail at Bundy and the trail at Rockingham,
Yes.
and probably the cap and the glove?
Yes.
And why doesn't the issue of the blood vial stand out in your mind?
I don't believe he's competent to talk about why he forgot to tell her something.
Could you repeat the
Mine
question?
were
please?
Wonder
Did you
Woman
consider the
under
issue of the
Bruce.
blood vial to be particularly important in terms of who collected it?
No.
And you were asked certain questions on cross-examination about whether or not you were anticipating the kind of accusations about the blood vial. Do you recall those questions that were made during cross-examination?
Yes.
Mr. Fung, were you anticipating those kinds of accusations?
No, I was not.
Were you surprised?
A little bit. Yes.
And in your mind, was the issue of precisely how the blood vial got from Mr. Van Adder, Detective Van Adder, out to the crime scene truck all that important to you?
No, it was not.
Did you know that it got out there in some way?
Yes.
Did you try to make a mental note in your mind as to specifically what was happening at the time that you got the blood vial?
Leading.
My only concern was to note who I got the item of evidence from and the time and the date that I got the evidence.
Did you do that?
Yes.
When you received the analyzed evidence envelope, or the evidence envelope rather containing the blood, did you make it a point to call out to people, hey, everyone, I'm getting the vial. Can everyone gather around so I can have some witnesses?
Sustained.
Argumentative.
Sustained.
Oh, I'm sorry, Your Honor. When you got the blood vial, did you make it a point to try to gather people around you?
No,
Did you make it a point to try to get people to notice what was happening so you'd have witnesses?
Sustained. Rephrase the question.
Did you make any effort to make sure that there were a lot of people around when it happened?
Objection. Leading again.
Overruled.
no, I did not.
Why not?
That's not part of, I would think it would be unprofessional for me to make a big deal out of collecting a single piece of evidence.
Did you try to do that with any other piece of evidence, get people to witness you collecting it on the 13th?
No,
Overruled. Overruled.
Yay, Kelly, thank you. He did just pull a check.
Now,
He
when you got
did.
on the witness
Thank you,
stand
Kelly. I'll put it
in this
in
case, did you
Discord.
recall all of the facts and circumstances as to specifically how the item was carried out to the crime scene truck?
no,
You haven't heard mine yet.
And when you were suggesting to Mr. Schecht various ways that it could have gotten out to the crime scene truck,
Objection. Misstates the evidence, not suggestions, testimony.
Sustained. Rephrase the question.
okay, maybe I'll read from the transcript, Your Honor. I'd like to read first from page
He's about to give us a page.
I'm all for it.
Yes, it's page 22,457.
I take it that's from the 12th.
It's from the 12th, yes, Your Honor. Do you recall giving the following answers?
Excuse me, just say. Counsel, do you have that?
Oh, it's starting on line 1 all the way down to line 18. Did afterward. Question. And you just refreshed your recollection by looking at your notes.
Okay. Okay. That was spicy today. No one went to jail. I have a feeling the judge is going to have to start just charging these lawyers a lot of money soon because he's just going to sanction everybody. Everybody's going to have to pay money. I have a feeling, though, that the defense is opening a can of huge worms. If they nail the prosecution where the judge actually sanctions them hard, they're going to get hit harder and harder and harder because they're worse. They do the same thing, only much worse. But we'll find out more tomorrow. You guys have a great day. I'll see you again real soon. Thank you so much. Bye, guys.